Our next case is Smith versus, Smith is PR for the estate of Jacqueline Harris versus Beaumont Health and Tri-County Orthopedics. This is a mini oral argument on the application, 20 minutes per side. The appellants, two appellants, you are going to agree on how to divide your time?
Yes, Your Honor.
Okay. And obviously, save time for rebuttal if you'd like. 2 minutes, fire-free, that can be waived.
Good afternoon, Your Honors. Karen Beach on behalf of Defendant Beaumont Health. I will be splitting an initial 15 minutes with my co-defendant, and we are reserving 5 minutes for rebuttal. This court asked the parties to explain whether the Court of Appeals correctly ruled that trial courts must apply the Dean and Duray sanctions factors before denying a plaintiff's motion to amend a timely filed witness list, where denial of that motion would result in the case being dismissed due to lack of a standard of care expert. This court should rule that the Court of Appeals erred by requiring the trial court to apply the Dean-Duray factors to a ruling that is not a sanction for 3 reasons. First, the Dean-Duray factors are not the right tool for a ruling where the affected party is not being sanctioned for violating a court rule or a court order. The Dean-Duray factors focus on the prejudice from a sanction that results in dismissal and whether the sanction is proportionate to the offense. Conversely, decisions on a motion to amend a witness list have their own standard, good cause, which focuses on the moving party's diligence and adequate explanation, and the prejudice resulting from granting a motion to add witnesses. Second, the diligent plaintiff who has a credible and reasonable explanation for amending his witness list has nothing to fear from the good cause standard. He does not need the Dean and Duray factors to stack the deck in his favor. Finally, requiring trial courts to apply the Dean-Duray factors for every ruling that results in dismissal would impair docket management. And indeed, plaintiff admits that the factors would have to be applied to every ruling resulting in dismissal of a case, including if an expert witness is found unqualified under MCL 600-2169. I invite the court to ask questions.
What do we do with the fact that it appears the trial court was incorrect in thinking that the discovery period had expired? I mean, is that relevant to, under any standard that you're looking at, whether she actually provided a proper, good cause analysis, even if in fact there was time remaining in the discovery period?
Your Honor, that was an error by the trial court. However, I think the trial court also properly could have considered the fact that case evaluation facilitation was only a few weeks away at the time this request to add a new witness was made. And anyone who's litigated or reviewed medical malpractice cases knows that the plaintiff's standard of care expert is one of the most important witnesses. All of the other witnesses, their depositions, their preparations are based on that witness. Case evaluation and facilitation turns upon the strength of the standard of care testimony by the plaintiff's expert. So with the parties proceeding to case evaluation or facilitation without having that testimony, that's a real impediment to the action being hopefully resolved on that basis, or proceeding to trial in a matter of several months, having deposed none of the expert witnesses. So I think that although the trial court got the close of discovery date wrong, I don't think that, considering the status of the case and how close they were both to case evaluation and trial, was an improper basis for finding there's no good cause.
But, I mean, that wasn't what you just articulated, which I think is a valid argument, was not the basis of the trial court's reasoning, right? I mean, it wasn't because, well, we've already had case eval and we've already had, or we're close to case eval. So when we're looking at, or at least the Court of Appeals is saying it needs to go back.
I think it was if you look at the trial court issued, several written opinions on these issues. And if you review the decision on the motion for reconsideration that was made on December 14th, the trial court discusses, you know, it's, Dr. Ball was uncooperative, this case is advanced, and I think that was, even if that didn't, the case evaluation date didn't make it into the opinion, I think it was still part of the consideration. It was certainly something the defendants were arguing.
A general timeliness
Yes.
issue and the effect
Yes.
on the defendant. Did the trial court consider the prejudice or effect on the plaintiff?
I think the trial court knew that by denying leave to amend, that plaintiff would not be able to litigate a medical malpractice case without an expert witness. And certainly that was true once plaintiff agreed that they would be withdrawing Dr. Ball in any event.
And is it your position that that's not required? I mean, whether she did it implicitly or explicitly, did the trial court not have to consider the effect on the plaintiff of the result of her decision? Or the potential prejudice? I mean, she considered the prejudice of the decision on the defendant. Is it error to not have considered it on behalf of the plaintiff? Or are you saying it doesn't have to happen, or it did, but it was more implicit?
I think that can be looped into the adequate explanation piece of it, is if plaintiff comes forward and says, you know, here's how I've tried to get in contact with this I need an expert witness, obviously. Here's how I've tried to get in contact with this expert. He's stonewalling me. I haven't heard from him. I have to add a new expert, otherwise my case is going to be dismissed. And so the court would say, well, you know, avoiding having your case dismissed is part of an adequate explanation for amending your witness list. I think you can roll it into that. Is it explicitly part of the good cause standard? Maybe it's not at this time, as it's traditionally been construed.
But doesn't Tisbury require consideration of that factor if it's going to result in dismissal?
I went back and read Tisbury, which is very short.
It is.
It's not clear whether, you know, the prejudice discussion was taking place in the context of the motion to amend or the motion to adjourn. But I think the problem with the Dean DeRay factors and the problem with the Court of Appeals ruling is that the Dean DeRay factors tip the scales too heavily in favor of always allowing amendment, because dismissal is something that has to be avoided at all cost. So if the good cause standard was amended to also consider prejudice to the moving party, maybe that's appropriate, but in terms of applying the Dean DeRay factors strictly, I think that that tips the balance too heavily in favor of the plaintiff, because you have to the dismissal should be a last resort. There's nothing to support the Court of Appeals' assertion that it has applied a more rigorous analysis when the denial of the motion results in dismissal. The opposite is true, and that's especially true in many of these cases where the expert has been found unqualified. And if we were to apply the Dean DeRay factors in that context, then the trial court would probably not be allowed to deny an amendment, because a plaintiff does nothing wrong when they select an expert that is not qualified. The plaintiff also has a built-in protection of an appeal of right if they're denied leave to amend on the good cause standard, because if their case is dismissed, then they have an appeal of right. Defendants, conversely, don't have that protection if the good cause decision doesn't go their way. And frequently, courts do find that a party has good cause to add a witness if their case would be dismissed otherwise. This frequently comes out the other way. We just don't see Court of Appeals decisions about it because the defendant doesn't have that appeal of right from the decision allowing the plaintiff to add a new expert. I will cede the remainder of my time to co-defendant. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Lauren Rhodes, and I'm here on behalf of Tri-County Orthopedics and Dr. Lennox. As my co-counsel so aptly summarized, this case involves the Court of Appeals ruling that there was an abuse of discretion at the trial court level. It is our position that the Court of Appeals erred when it reversed the trial court for abuse of discretion and dictated that the Dean factors are applicable for a couple key reasons, one of those being that the good cause standard is actually the appropriate standard. And under that standard, the trial court's denial of plaintiff's motion to amend was not actually a discovery sanction as Dean and DeRay specifically consider. It is our position that the Dean and DeRay factors are specifically intended to address discovery sanctions, and as a discovery sanction was not implicated here, it was not necessary for the trial court to impose those factors. So these defendants rule that, excuse me, lost my page. So the trial court erred in its analysis when it applied Dean and DeRay because the good cause standard is actually specifically implicated under the court rules. It's MCR 2.401I2, where it provides that a trial court may order any witness be not listed in accordance with that rule, may be prohibited, and in fact will be prohibited, except upon good cause shown. That rule does not implicate or discuss sanctions, as I previously mentioned. As long as that witness list is timely filed, as plaintiff's counsel did timely file their initial witness list in this case, under this court scheduling order, there's no violation of any order or court rule that would require the implication of sanctions under MCR 2313B.
Counsel, how would you define good cause? How are we supposed to do that? I'm just wondering, it feels like the Dean factors are sort of an effort to get to that. I realize arguably a different context, but what would be good cause?
Certainly. So actually, the Court of Appeals in Morris, as well as Redfit LLC, both specifically contemplated that. And in Redfit, following Tisbury, where the Court of Appeals reviewed for a similar factual scenario, except came out on the other side, they specifically requested that the moving party needed to adequately explain their reasoning for any delay in naming a sufficient witness or a valid witness. And they also needed to assess whether the non-moving party would be prejudiced, as my co-counsel had discussed with you earlier. In this case, the non-moving party was the defendants, so it was the Court of Appeals' role to assess whether the defendants were to be prejudiced. As my co-counsel noted, with trial imminently approaching and facilitation or case eval also imminently approaching, there was significant prejudice to the defendants. I think facilitation was a matter of weeks away, and trial was less than 3 months away at the time that that plaintiff's counsel asserted to file the late amended witness list.
Does the fact that the trial court was incorrect on how much time was remaining and the timing of other things call into question her analysis under that standard? Because saying the prejudice to the defendant given the times of facilitation and trial and all those things is a very different thing if discovery is closed, or if discovery is not and depositions are still being scheduled and facilitation hasn't happened and those type of things. And if she's mistaken on that, is the analysis mistaken?
I don't believe so, Your Honor, because ultimately the period of 3 months is a very short time to continue to conduct expert discovery in particular. With multiple schedules moving between the attorneys, the defendants, the doctors, the court reporters, there's a lot of coordination that needs to go, that needs to come together in order to schedule expert depositions, and certainly before a facilitation. We're also then factoring in the facilitator's schedule, which their lists are several months out at any given time. So I think that even though she was mistaken on the discovery closure date, the fact remains that discovery was going to still continue to need a significant amount of time to be completed. I mean, at that point, we had no standard of care testimony from from plaintiff's side. You know, we don't have any information about their qualifications. We don't have any information about the standard of care testimony that they're anticipating to bring against our defendant. And that is significantly prejudicial to a defendant and to their preparation of their defenses in time for trial. I see that my time has finished unless I have a little bit more.
You do, you
Okay,
have
excellent.
6.
So no, I understand that that Judge Grant did really hammer on this closure of discovery, but I think that the analysis still would have been the same. It still would have mattered that this time was gonna need to be taken to address the standard of care experts' testimony. And then, as procedure usually goes, we would have need defendants, experts' testimony, and so on. It was still going to take a significant amount of time that surely would have been, put us right up into, the night before trial.
It wasn't, didn't the parties agreed to extend discovery basically almost up to the date of trial, right? It was December and trial in February,
Yes, correct.
So the understanding that discovery was gonna be ongoing up to trial was understood
Yes.
before this issue came up.
Yes, I would agree with that. I think that the trial, or, the trial court and the defendants, all parties really were trying to be respectful of the fact that we don't want to waste the court's resources. We don't want to have to move trial if we don't have to. We would really like to get this completed in a timely manner. And that's really what precipitated the motion to strike the amended witness list and, in fact, this litigation. We felt that plaintiff's counsel was a little bit hiding the ball and whether this expert was qualified and was, in fact, engaged in a deliberate delay, which is one of the Dean factors. In fact, the defendants also assert that in our supplemental brief, you'll see that we went through the Dean factors and noted that even if this court finds that the good cause standard is not the applicable standard or is not the best standard to fit in this specific case, then the Dean factors still apply. And they still, in fact, weigh in the defendant's favor.
Counsel, so in your view, did the trial court judge apply Tisbury here?
Yes, I would agree. I think that the trial court specifically, when you look at her reasoning on the record, although it's perhaps not as thorough as we wanted, the motions that led up to her decision discussed these issues. The motions addressed the many procedural issues and the many evidentiary issues that they were concerned by leading up to the motions. And they also discussed the fact that the defendants would be prejudiced by naming this late, allowing a late amended witness list. I think that Judge Grant gave consideration to that, and although she did not discuss each of these factors maybe specifically on the record, I don't think that that's a sign that they were not considered, because I do think that her, what she does say on the record and in that transcript of the October 12th hearing does go to some of the, in not so many words, does go to consideration of these issues. And I think even applying the Tisbury test here, as Morris did and as Redfit did, the moving party plaintiff did not adequately explain, and they didn't provide any evidence of their, of what was taking so long and why they could not reestablish contact with Dr. Ball. There was never an affidavit of, speaking to their attempts to speak with to get back in conversation with the doctor. There was no shared emails or correspondence regarding what efforts they had made to actually reestablish contact. And that was, I think, one of the things that Judge Grant was also considering. There was no evidence. She offered plaintiff to show her cause. She said, just show me cause, and I will consider your motion to amend. Give me good cause. And plaintiff did not show good cause sufficient to grant the motion. And, it is under MCR 2401 I2, it is not necessarily a discovery sanction to discuss that issue. And it was within the trial court's discretion under the court rules and under the case law that has come out of the Court of Appeals to be able to consider these issues.
If we agree with you that good cause is the proper standard and a remand to apply the good cause standard is appropriate, is dismissal of plaintiff's claim compatible with our recent decision in the Otkin case, O-T-T-G-E-N, Otkin?
Your Honor, I believe it is. I understand that it's not necessarily, a failure to have a valid affidavit of merit is not necessarily fatal to a plaintiff's claim. I understand that, arguing a case on its merits is certainly valid. However, in this case, plaintiff had the opportunity to do so, and, you know, for several months, if not years, leading up to this, and then did not provide any evidence, did not provide any expert testimony to justify their position. I think that if we were to pursue, you know, to pursue the case on the merits, and even if I'm sorry, may I revisit your question? You said the good cause standard, if it was to be
Let's say we apply
applied.
the good cause, is dismissal of plaintiff's claim compatible, given the Otkin decision? Here, there's no finding that plaintiff intentionally manipulated the affidavit requirement to extend the statute of limitations, right?
There has not been, no, that's correct. It is defendant's position that there was, you know, some attempt to hide the ball because they canceled the deposition on the nth hour. You know, we believe that the trial counsel found out that his expert was no longer qualified under the statute, that he had retired and, you know, did not meet MCL 621-69. However, regardless of that fact, I think that there's enough here, specifically in the Court of Appeals decision in Morris as well as Redfit, that despite the fact that dismissal is maybe incongruent with, you know, with Ogden's position, there's still this issue of whether, if I may finish my answer, that would be excellent, thank you. I think that there's still the issue remains. While dismissal, you know, if it's not being implied as a sanction, it's still available under the court rules. You know, whether it might be inconsistent for the same, under the same factors and reasoning as Ogden, I think that this case is sufficiently different such that the court rules and the case law that have already come out of the Court of Appeals are a better fit to address that issue and to make dismissal a viable and suitable option.
Is the remand better to the Court of Appeals or to the trial court for that?
You know, I don't know, Your Honor. I think that the Court of Appeals needs to address this issue. I think that this case is now here because there should be some guidance on whether the good cause analysis should be applied. I think, as my co-counsel stated earlier, you know, these cases usually don't get here, and this issue has not yet, you know, come before the court. So I do think that whether it's in your court's hands or whether it's remanded to the Court of Appeals, I do think that a decision by the Court of Appeals or an appellate court would be appropriate.
Okay.
Thank you very much.
Thank you.
Good afternoon. May it please the court, Beth Whitman appearing on behalf of the plaintiff. I will waive any free fire zone, so please ask away. I want to address first this question or this issue with respect to whether or not this constitutes a sanction. And I think it does. I think that's exactly what we have here. Under the court rule, 2.401I1, the party has to file a witness list within the time period that's set forth by the scheduling order of the trial court. Under I2, it specifically says that if a witness is not listed as required by the court rule, the court may prohibit that witness from testifying at trial except upon good cause shown. That's the sanction. The sanction is the preclusion of that witness's testimony. Now, it's our position that when the preclusion of that witness's testimony, when that sanction is employed in a situation where it's going to result in the dismissal of the cause of action, or hypothetically also a default of a defendant, that the trial court has to exercise that sanction cautiously and has to then utilize those deemed factors before imposing such a sanction.
What about counsel's argument, though, that if that's the case, that any time the dismissal of the witness is basically the dismissal of the case, then we have to go through this whole analysis. So apart from just the failure to amend the witness list or failure to timely file, so any time, at least in a med mal case, and
Yes.
perhaps in a number of other cases, are we creating now some new analysis that always has to happen?
And
Or
I
is
don't-
it only in this context?
I don't think so. I don't think it's a new analysis. I think, when you look at this court's decisions based upon North, MacArthur, those cases involved not only discovery violations, but also a failure to, the case to progress. This court said, under those circumstances, before you dismiss a case, you have to look at these types of factors. You have to look at the prejudice. You have to look at the issues that Dean, these cases are the precursor to Dean. So as a result of that, I don't think that this really creates anything new. I think this is exactly what this court has always required trial courts to impose when we're talking about dismissal.
What about the argument that Dean sort of stacks the deck against dismissal?
And I think that may be very true, but I don't think there's absolutely anything wrong with that. I think that's consistent with what this court has indicated is the policy of this state, that we want to have litigation determined on the merits. That's precisely what we want. So I think any sanction that is going to result in the preclusion of a witness, that's going to result in dismissal, whether it's on the plaintiff's side, whether it's on the defendant's side, I think that really has to be imposed cautiously based upon this court's rulings, prior rulings.
Counsel, why would
Yes.
we apply Dean versus Tisbury?
Well, it's our position too, obviously. I think there's a lot of overlap between a lot of these factors that we look at between Dean and Tisbury. I think the one that the defendants are mostly concerned of is whether the imposition of some lesser sanction would be appropriate. I don't think Tisbury necessarily says that, but it does say one of the issues that you have to look at is whether or not it's going to deny the party a decision on the merits. So I think there's a lot of overlap between the two of them. I don't think that it is going to be this huge burden on trial courts to go through the Dean factors versus the Tisbury factors in order to make a determination of whether dismissal would be appropriate. The second issue that I wanted to kind of get to and discuss a little bit is this issue with respect to the qualification of the expert and the alleged gamesmanship that was going on with the plaintiff. So the defendant injected this issue of the qualification of Dr. Ball and they argued in response to the motion to amend the witness list that there was in fact gamesmanship because we didn't want him to be deposed because that would really clarify the fact that he was not in fact qualified to sign the affidavit of merit. That then kind of led the trial court to make that determination that we're not going to allow the amendment of the witness list, that, I think the trial court said something along the lines of plaintiff had over a year to figure out the issues with their witness and the qualifications of it. Well, the problem is, obviously, number one, is the issue with the witness was that he suddenly became uncooperative. That was not something that came up that we could have foreseen within that 1 year time period, but the injection of this issue is problematic because, as this court's aware, any challenge to an affidavit of merit has to be made within 63 days or a later time period if there's good cause shown. Now, if the court had actually engaged in any sort of analysis with respect to this good cause, one of the questions would have to have been, when did the defendants learn about the fact that this expert may not have been qualified? And one of the depositions that was attached by the defendants was taken by one of the counsel in this case, and it was taken months before the litigation was commenced in this case, and that's what they pointed to say that he was not in fact qualified. So that suggests that the defendants were in fact aware of the fact of the possibility that Dr. Ball was not qualified well within that 63-day time period, and chose not to challenge him at that time, and instead wait until later on when it would have been much more difficult to amend a witness list to add a new expert.
Counsel, obviously opposing counsel has made the point that the plaintiff did not do enough to set forth why the expert was no longer qualified
Right.
and the efforts made to sort of comply with the rules.
Yeah.
Could you respond to that?
Yes, and that really goes to that, one of the Tisbury factors that they focus on. It's their position that the Tisbury factor has to require diligent efforts to secure the witness's presence. I think that's wrong. I think that's not what Tisbury stands for. As opposing counsel indicated earlier, Tisbury dealt with two issues. It was an amendment of a witness list, and it was also an adjournment, a motion to adjourn. And that second factor, the diligent efforts to secure the witness's presence, that went to the motion to adjourn. And it's clear that that was the case because the court cites to the Sleeman case, which is specifically solely on an issue of adjournment. So really, what Tisbury talked about with respect to a motion to amend, that diligence question looks instead to whether the party caused repeated delays in the litigation due to a lack of diligence. And we don't have that here. So it's an important distinction because this is a factor that the defendants say applies here based upon Tisbury, and it's our position that it absolutely does not. There was no, they argue about, we didn't have an affidavit saying that we couldn't contact him. We didn't come forward. No, again, there's no reference to an affidavit in Tisbury either. But, they say we didn't prove enough that he was actually uncooperative. But I don't think that that is an actual factor that we look at under Tisbury. But Tisbury, again, good cause, prejudice, I don't think it's really that distinguishable from the Dean factors. Kind of the last point that I wanted to make, Beaumont Hospital makes the argument that treating the decision to prohibit a witness as a sanction would improperly insert considerations of justice and proportionality into the good cause standard that governs these requests to amend the witness list. But it's inappropriate to remove questions of justice and proportionality from a trial court's decision in this case. It's in sharp contrast to the stated purpose of the court rules, which is to secure the just, speedy, and economical resolution of actions, and avoid consequences of error that do not affect the substantial rights of the parties. And that's precisely what we would submit occurred here. And it also, and this is an important point too, it also affords greater protection to parties that completely fail to file a witness list versus a party that filed a timely witness list but just needs to amend it at a later time. So if we're going to apply the Dean factors to somebody who, blatantly, I suppose, violates a court order versus somebody who complied with the court order but needs to amend the witness list at a later date, that doesn't make any sense. Those are the points I had. I would be happy to answer any other questions if the panel has any. No? Okay. But, I did have one other thing. I'm so sorry. Justice Kavanaugh, you were talking about the question of whether the trial court was, whether that factors in because she was dead wrong on the discovery cutoff date. I think it absolutely does. I mean, you can't have a proper use of discretion when you're wrong about the fundamental facts that you're using in order to make a decision about an amendment that is requested here. And I just wanted to point out too, when the plaintiff first requested to amend the witness list, now they just filed an amended witness list, what the court said was inappropriate and needed to be used with a motion, but that was done in September of 2022. Discovery wasn't closed until December of 2022. Facilitation wasn't until the same date as the deadline for the discovery cutoff, and trial was scheduled for February 7th of 23. There was plenty of time in order to make sure that the witnesses were deposed. In fact, we had already named a new expert. We had provided deposition dates for that expert, all of which fell within the discovery time period. So based upon those facts, and the trial court judge didn't even acknowledge any of that. There was no acknowledgement of that. So based upon that, based upon the dates, based upon the fact that we complied and we were able and willing to comply with the scheduling order and the other dates, I think absolutely this was an abuse of discretion, I think under any test that you want to apply.
Thank you.
Okay, thank you very much.
Thank you. The matter will be submitted.